Okay, well, this is Ron Washington, and I'm the Assistant Director at the Metropolitan Development and Housing Agency, and also a SHRM Ambassador. And I have the pleasure today of introducing our two speakers. Our first speaker is Kathryn Siegel, and she is the shareholder and executive director of the Labor Practices Group at Littler. She oversees strategic planning, practice ops, talent development, and the delivery of uh, legal services across Littler's national platform. She advises in the full spectrum of labor and employment law. And in college, she started and founded the Vanderbilt Labor and Employment Law Society. Our second speaker is RyAnn Hooper. Sorry about that. RyAnn Hooper. And she has over 2 decades of experience advising labor relations, employment, and workforce strategy across both the public and private sector. Prior to joining, RyAnn led a Fortune 100 employment law group. She also has spent time at the NLRB and also has had a private practice. Please join me in welcoming Kathryn and RyAnn.
It's great to be here.
Thank you for the introduction. All right, I am going to do the hardest part of this, which is pulling up our PowerPoint. So just hold on with us for 1 second as I get this pulled up for you all. And I have to have a little bit of your faith that I know what I'm talking about on AI when I am still struggling with the PowerPoint pull up. But there we go. Hopefully everyone can see that. We can see your chat. I know that Ron, I think, is going to help with that as well. But if you've got questions as we go along, RyAnn and I are happy to try to address those to the best we can in the limited time that we have. So we're thrilled to be here with you today. Hopefully, we're going to give you some helpful things to think about in this overwhelming world of AI that we are all dealing with right now. I like to use the framing on AI that it's like the train is leaving the station and we are all really running to catch up. So know that RyAnn and I are in the same place as well, that we are really still doing that run to catch up as this continues to evolve on an everyday, every hour basis in regards to the ways in which AI is coming into our workplace and the laws that are changing around the use of AI. So what are we going to cover today? Basically this. It's already in your workplace. I know that you know that. And we use AI as kind of a scary term. It's this new thing that showed up in the last few years. But newsflash, we've had AI in some form or fashion for a much longer time. We've just kind of rebranded it with this AI terminology and developed new fears around it. But things like Google search, things embedded in your word that would help you to see if there was a better way to say something. There's been a variety of different AI tools that we've been using for, frankly, a decade. So destigmatize that a little bit. We're just talking about the new evolution of this. We're going to talk about where HR and AI kind of run into each other. What does that look like in the employment life cycle? There may be some you haven't even thought about yet, or that your organization isn't using. So to be aware of that. We're going to talk about the regulatory pressure points. Where are we seeing the states act right now? RyAnn will talk a little bit about what the federal is doing or what we anticipate happening there, but this is largely happening at the state level. What are we seeing the states get focused on? What do they think that they're that people within their states are worried about in regards to AI. We're going to talk about the ethics. Where do we run into issues, not just legally, but like as an HR professional, what should you be thinking about in regards to the implementation or use in your organization? What are those moments where you need to hit the pause button and think about, what am I doing? What is my thought process? How is this substituting for my judgment? Where do I need to be human in loop with this? We're going to talk about the litigation trends. I always like to be cognizant of that when I'm doing advising on for clients on policies or implementation. What would the enterprising plaintiff's attorney do? And RyAnn is going to talk about what is the enterprising plaintiff's attorney doing. And we're certainly seeing a lot of enterprising plaintiff's attorneys these days coming out with new theories about AI and how it interacts with the employment laws that we have in place. And then governance and action guidance. What are our practical steps for you all for today that you can take away to think about within your organization? And I know I talk fast, but hopefully I know you all are HR professionals. We're used to talking fast and getting things done. We want to make sure that we get through this material with you today. All right. So I'd previewed this a little bit, but I think it's important to just remind ourselves AI is not something brand new and scary that's just showed up. It's been in our workplace for a long time. And many of you, whether you know it or not, are probably using AI in some form or fashion in your HR processes. So this survey that we're looking at found that 54% of employers are already using AI in HR and recruiting. So this is the use case that we've seen the biggest adoption very quickly to help screen through those resumes, help us figure out who's worth interviewing. I totally relate to that. I am a hiring manager myself, and just getting through those resumes to figure out who's a good match, especially when you're doing that at scale, it makes a lot of sense that we've got AI being incorporated there. It's doing that resume screening, even candidate ranking, even a chatbot pre-screen, creating your job descriptions, some of the biggest use cases for AI. At the same time, employers say 84% AI is their biggest policy and regulatory concern. And that's really understandable because, as we talked about, and you all know, this is evolving every single day. We're getting new state laws. We are getting new theories on, legality of AI and how it can be used ethically. Those enterprising plaintiffs' attorneys thinking about what are the kinds of lawsuits that we could come up with. It's not just whether AI is involved. These plaintiffs' attorneys are digging into what influence is AI having over that decision making, and what bias might that AI tool be bringing into this without the employer's knowledge, or where the employer should have knowledge but maybe wasn't thinking about that. And a lot of the places we're seeing those theories are when AI is doing exactly what we're asking it to do, which is ranking, scoring, predicting, recommending. That may all become evidence in litigation. We're also seeing this, and again, we're going to talk about the different places that we're seeing AI kind of percolate through the employment life cycle. Employers using it for performance summaries, putting together 360 reviews, productivity scoring, attrition prediction. I just read about helping put together an initial draft list of people for a RIF, considering some objective factors that the AI tool was able to screen through the employer system. And I don't know if you all saw when we joined, but there's an AI note-taking bot that joined the meeting. So we're seeing a whole lot of that joining all of our meetings on, an everyday basis. So a lot of different places that even, maybe not the most technologically sophisticated employer is integrating AI into that employment life cycle. So, what counts as AI? So it's not just when you click through and go to Copilot or ChatGPT, right? As I mentioned, there's a whole lot of different places that companies have incorporated AI where you might not even be aware of it. First, there's no universal legal definition of what it is when we're talking about quote unquote AI. It's really about what is this technology doing, right? Is there artificial intelligence that's being embedded in this tool? And then what is that tool doing in particular, right? The biggest spot for regulatory focus is when that algorithm, as I mentioned, is doing that ranking, assessing, recommending. Um, and as we'll talk about shortly, you don't need new laws to say, hey, that tool or that person brought bias into that decision-making process. And so that is unlawful under whatever law is in existence. Also, AI creating content using generative AI, right? So that is going in and saying, create a cartoon of this, replicate this, change this, using those tools to create what we call generative AI. We consider kind of medium risk some of those tools that we're most familiar with, those Copilot, the Chat GPTs, et cetera. I don't know if you guys are all familiar with what we call human in loop. Okay. So, RyAnn, maybe you'll correct me, but as I understand it, she's more of the expert than I am because she spent a lot of time at her prior employer really digging in and owning this for the employment litigation and advice function. But it's really, is the human that's still involved in the AI process the one doing the decision making? Are they the one leading the tool? Are they treating AI like that junior worker that's doing some of the work in the background, but they're the ones kind of giving the instructions, telling them what to do, telling them what matters, factoring that all in, and then evaluating the output and making decisions with their own judgment. So the more that we continue to have human in loop, ensuring that there's not bias being built in, ensuring that there's clear instruction as to how things are to be performed, ensuring that that output is being reviewed by that human with their judgment before it's being relied upon, cuts our risk. And then one of the lowest risk is the providing support, right? So just tools that are doing some of your, take these notes instead of me typing up those notes, find a common availability in our schedules, much lower risk when we get to that realm. So the takeaway from this slide is, AI isn't just one thing. We're talking about a broad spectrum of tools and uses when we're talking about AI, and there's different risk and ethical considerations depending on that tool, how that tool is being utilized, what input we are giving to that tool, what instruction, what parameters we're putting around the use of that tool, and how much the human is in the loop, how much the human judgment is really shaping what that tool is doing. And so, as I previewed, it's not just at the entry point to employment where we are seeing the use of AI tools. We are seeing it in a number of different places, from that resume screening, the applicant ranking, which again, as you saw, is very heavily where AI is being used, where we've got such a high percentage to that hiring, the interview scoring, background screening, but during the employment life cycle as well. So performance reviews, I will confess, I don't know if this is a crime, RyAnn, you'll have to tell me. Not a crime. Employment law is not a crime, but is it a violation? I took my performance reviews for the people that report to me, and I had AI put together a summary of those that I could read more quickly to digest them and to, make recommendations and to kind of review those people in comparison to each other. You get a big performance review and you're like, okay, this is all put together. It's got everyone's feedback, but how do I compare this person to someone else? How do I determine who's more worthy of this big raise? And so we're seeing it being used for some of those purposes. Productivity monitoring, definitely one that can create some friction that gives employees anxiety as to whether, how often are they moving their mouse, how much of their day is spent productively with their computer logged in. And then at the point of separation, as I told you, helping to identify folks for a RIF, putting together that performance documentation. Those are all areas as well where we're seeing this use. And so our first recommendation for you all is to just think about this when you're using any of these tools. Where am I using AI? Be cognizant of it, right? What is potential legal risk of what I'm doing? Is there bias that could be built into this? Am I doing anything to ensure that that isn't being built into the system, that I'm not relying upon this tool or not aware of what biases this tool might have built in? And what ethical issues might this present from this use?
Thank you. That was a great kind of kickoff into what some of the pressure points may be now that you've kind of identified, okay, we are using AI. It's in more places than we think. What are some of the pressure points it kind of creates? So, when you're thinking about pressure points, sometimes this is legal pressure points, sometimes this is ethical pressure points, sometimes these are business pressure points, right? Um, and I'm going to say that they can all, regardless of that category, fall into kind of three places within the kind of specter of HR law, right? You're going to see pressure points in discrimination. That's the legal kind of aspect. Privacy. That's the data management aspect. And also governance. That's how your organization reacts to the pressure points, right? So if you don't have kind of a North Star and an idea of where you want to go when these pressure point hits, then the pressure points become even greater, right? So let's kind of go to pressure point one on the next slide. And we'll talk about the one we all know, right? Which is discrimination, right? Um, what's old is new again. As Kathryn mentioned, AI is not new, and the laws that govern it are not necessarily new, right? So the biggest misconception is often is that AI is not biased because it's a program and it doesn't discriminate. But employment law still applies here, and it doesn't need discriminatory intent, right? So if you have something like a facially neutral tool that disproportionately disadvantages one group of people, or if you have something that systemically kind of excludes one particular class, then your risk of discrimination appears, and you're talking about standard civil rights and Title VII law, right? All that AI did was systematize your process. So it's now made it on a larger scale and created kind of a class action and kind of litigation risk. So you can still have your traditional disparate treatment, traditional discrimination claim, right? It would look just like any claim that you've previously seen come through your HR or legal department, right? And you're going to have the same similar kind of enforcement pathways, right? So you'll see state human rights agencies, private class actions if you're dealing, for example, with California or other states' attorney generals. And you'll have kind of local examiners looking at AI the same way they would if they were looking at a regular kind of action by an employer just now with a system. And the same kind of holds true when you're talking about a collective bargaining context, right? If AI is making the decision or creating the threat, it's the same concept. It's like an agent of the employer. So you kind of get the same kind of theories and all of those things. So we know that federal priorities have kind of shifted a bit. But even though federal priorities have shifted, we're still seeing these civil rights law applying at the state level. And in some states, they're codifying some of those existing civil rights laws and putting them on the books in a way that makes AI more visible. So the kind of practical takeaway is simple, right? AI doesn't create new discrimination law. The law's already here. It creates new ways to violate kind of existing discrimination law. So you have to think of it in that way. You know the framework. Now you just have to think of it with this kind of AI lens. And the employer still remains responsible for anything that AI is doing. You can't kind of say, AI did it. It's not my issue. That is one of those pressure points, that it is an extension of the employer's action. So once you kind of start thinking about things with this old is new again, the existing discrimination law lens, we have to talk about the second pressure point, right? And that's the privacy point. There is a whole bunch of data going into AI to make it efficient, right? So when organizations evaluate AI, they shouldn't just look at bias. That's the discrimination piece, right? They should also look at the data, the inputs, the client information, the employee information that's going into the tool. And this creates kind of another pressure point and another place to kind of think about your ethical obligation and your risk, right? So privacy kind of may prove to be a little bit more of a risk than even the discrimination piece, right? you kind of have three places where this kind of pops up, right? So let's talk about the laws. You have biometric laws. So there are lots of different AIs, and you can interact with AI in lots of different ways, but some of the AIs that create the most efficiency, particularly in the recruiting space, deal with things that listen to people's voice, transcribe words, gauge sentiment, understand if someone is actually there, use a biometric fingerprint to log into your computer. That's, various different cybersecurity software that's used to kind of gauge whether your employees are in fact at work. So there are a lot of different things that use fingerprints, facial geometry, voice prints, retina scans. And in that space, we're no longer talking about employment law, although it impacts employment law. We're really entering into biometric privacy law, right? And there are certain states that have said there are certain requirements that you have when managing that information. They force that ethics, right? So Illinois is one of the biggest ones, right? You have Illinois BIPA, and it remains kind of one of the biggest statutes kind of in this space. Because if you are not collecting that information properly, if you are not treating it with the sensitivity that's required, if you are not disclosing that you're collecting this information, if you are not properly storing this information, if you are not ensuring that the data is not accessible in certain ways, then it creates a huge kind of litigation risk for you and also a reputational risk when you kind of take that out in the broader community. So you can collect the information, but there's a whole bunch of obligation that you have after that to then ensure that you're using the data ethically. So just some other states to think about when you're talking about biometric information. We talked about Illinois. Colorado's another one. Texas. You have localities within Washington as well as Washington State. Seattle has one on the books. And so some of these are popping up across the board as people are kind of demanding more transparency. And so you have to have a kind of a North Star in terms of how you're going to deal with this information. A second kind of pressure point that comes up in the privacy space that impacts the HR space is monitoring and wiretapping, right? So this is the meeting transcription tool when we first logged into this meeting, or the AI note taker. It can also be in your call centers, right? Where you're scoring either a customer's interface with the call or how your employee responded on the call. It can be in keystroke monitoring and determining how productive your employee was that day. Each of these kind of raise separate legal questions, but they all are kind of regulated by existing privacy laws that are on the books, right? And they're not new laws. You don't have to look to new legislation to kind of cover them, right? There are wiretapping laws on the books. So one example is in California, there's a law called SEPA. It's a law from 1964. It's an older law. It talked about wiretapping and when someone's collecting information about how you're interacting with like keystrokes and things of that nature, then potentially you're tapping someone's wire without consent, right? And this is kind of a space where you're seeing, even though you're collecting employee information about productivity, people are kind of attacking that under wiretap statutes, right? And it's creating a new emerging risk. So several states kind of require all party consent before you record, so you have to think about that. When you're talking about recording any type of meeting, you have to think about the ethical obligations in terms of what are you going to do with the information now that you've recorded it? How are you going to store it? Are you going to fold that into whatever your data retention policy is? If something comes up, say in a collective bargaining context where you've recorded something that becomes a subject of an unfair labor practice charge, or something is recorded after and an employee has left and you need that information to defend in an employment litigation suit, how long are you going to retain that information? And when does it become that you've destroyed evidence that could have been useful? So you have to think about that in terms of data retention and other things and what your ethical obligations are there. So privacy is a big one, right? And it can cause a heavy burden and you have to kind of be aware of it. And then the last kind of category where data privacy shows up is your employees are using AI, whether you know it or not, right? There's the enterprise version of any AI that you've accepted and the vendor relationships that you know about and you've categorized. And then there's your employee who's just trying to keep ahead of the curve that is entering your company information into third-party websites and other places to just get their job done. And you have to have an understanding of where that is, because that is also a risk and something that you have to control for and manage. And it might inform some of your decisions kind of in-house in terms of what you do. So when you're looking at all of these pressure points, the easiest way to manage them is to have some type of governance, right? Organizations that know how to govern and have stakeholders who are responsible for this and think about this subject and coordinate the efforts and take inventory of the AI can help avoid some of the pressure points and also have kind of people responsible when those pressure points come. So move to the next slide. So let's talk about legislation in terms of where the law actually lies when we're talking in the space of AI. The federal landscape is, there are the existing laws in the books. That's Title VII, everything we already know. We know that the FTC has kind of made it clear that deceptive, unfair AI practices will violate consumer protection laws. But beyond that, we don't have any kind of national federal AI law, although there have been attempts. None of those have kind of gone through, right? So on this left column here, we talk about the laws that might impact your AI. Many of them are privacy laws because some privacy laws are appearing in more of a federal scope, although not as significant as they are in Europe, right? So you're going to have HIPAA, you're going to have CAPA, the law that protects children and images and use of children's information. You'll have copyright law, right? You'll have FTC in those communications. And then you'll have your basic employment law statutes. Those things still apply. In the middle column, we'll talk about where Congress is trying to activate some legislation, but nothing has kind of gone through. So they've introduced dozens of bills covering everything from employment decisions to transparency to algorithmic discrimination and impact assessments to addressing deep fakes or people showing up in your workforce that you did not intend to have there. What's notable is not that any of these are going through because none of the legislation is passing. But what's notable is the direction that all of the bills seem to be floating towards regardless of political party. So it's clear that there's a focus on greater transparency, human oversight, so human in the loop, making sure that humans are actually making decisions and not the AI. And that there's accountability for high risk systems that we know bias is just inherent or hallucination is just inherent. And we need protection against that to ensure that decisions are still made in somewhat of a fair and transparent manner. So this kind of gives you a sense of where the ethical direction of these laws are going, right? Because all of the new legislation that's coming out is still focused in that direction. And then the right column here on this slide talks about what the executive branch is doing, right? And the executive branch has changed course a little bit from some of the existing laws on the books, as well as some of the direction that some of the proposed laws are going. But it hasn't rescinded any kind of prior law per se, right? It's just kind of set a new direction and potentially a new priority. So let's talk about some of the E orders. There's EO 14179. It rescinded what was called the AI safety EO, and it replaced it with this idea that we're going to focus on innovation and not necessarily reduce regulatory barriers towards AI. So we're not going to put guardrails on AI per se. We want AI to go forward. This is a policy shift. It's not something that's changed kind of the legal focus. You have a second EO that's 14281 that agencies were kind of directed to evaluate their prior guidance on disparate impact theories, right? And this kind of impacts your Title VII. This again affected the enforcement priority, but it doesn't eliminate employer obligation to evaluate bias and disparate impact when they're implementing kind of AI tools, right? So that's still kind of an ethical ethos that's there that employers need to pay attention to. And civil rights laws, as we've already discussed, still exist at the state level. There's also kind of this AI litigation task force at the executive branch level. It is involved in coordinating AI litigation, right? So that tells you, even though the priority is shifted to kind of perhaps focus on innovation and other things and not regulate AI, the executive branch still understands that AI litigation is on the uptick and it's going to grow. And so this is an area that people need to be thinking about to either avoid litigation or to be prepared to defend litigation And to do all of that, you need to have that ethical ethos, governance, document management, and privacy kind of data management that we spoke about, because that's kind of the only way to kind of push through. So let's talk about the state level on the next slide. The state level is kind of where all the action is, right? So last year, I could have pointed you to one or two statutes as outliers, but basically said to you there aren't really too many statutes in the book that talk about AI. That's really no longer true. Right now, our legislative tracker kind of pulls hundreds of AI-related bills affecting employment and consumer transparency and privacy across dozens of states. So the question is no longer, is AI going to be regulated at the state level? It's a question of what AI model is your state going to adopt? Everyone is kind of approaching regulation of AI in a different way, right? Are they taking on everything? I want to regulate your governance, how you interface with consumers, what your actual tool does, whether it's biased. Or am I just asking that you kind of manage employee data and be transparent about it, right? And so you have to look at your state and see where you're doing. So let's just give an overview of some of the states, right? One of the first laws on the books was NYC's Local Law 144, which basically was a little bit more of a comprehensive law, although it did have some gaps. The idea was that if you were deploying a tool in your recruiting space that helped make an employment decision and was the major kind of decisional factor in your decision to hire or fire someone, then you needed to test that tool and post certify that you had kind of tested that tool and post that information. It was pretty kind of easy to route around. As long as that wasn't your major decision factor, people often were able to get around that and not kind of have to deal with the compliance portion of that law. Colorado kind of came next. And while Colorado we thought was going to be this law that was all encompassing, it's kind of been scaled back a bit, right? This was one of the first comprehensive AI bills. It was initially titled SB 24205. It basically focused on if you had a tool that was a high-risk tool, meaning it made employment decisions. It regulated you as a deployer. It regulated the developer. It required that you do an impact assessment. It required you disclose and out yourself to kind of the Attorney General if your tool did in fact discriminate. And you had kind of this reasonable duty of care to prevent algorithmic discrimination. So it was very onerous. You had to implement a lot of different things and conduct these things on an annual basis. You kind of got the power of businesses with this one because the business community reacted. And within almost a year, that was shifted, right? And that law was clawed back and kind of branded as SB 26189. And now it looks very much like a consumer privacy law, right? Instead of being that kind of, you have to do all of these things and we want to manage how you use AI. It's now saying if you're pulling data, you have to be transparent about it. You have to give people an opportunity to kind of correct their data and make sure everything's correct. And you basically have to be transparent about it, right? It's more of a targeted framework centered around transparency and human review, having a human in the loop. Our most recent law that's of significance came out of Connecticut in May, and it is more of a comprehensive law, similar to Colorado, but a little bit more expansive. It goes into effect in October. It kind of gives transparency across the board. It addresses chatbots, workforce impact. It requires that you have a governance procedure and kind of regulates that governance procedure. It makes clear that having AI made me do it is not a defense, right? It kind of codifies all of the kind of litigation that we'll talk about in future slides coming out about AI and ensures those safeguards. So this is kind of the new model. So you have to look at how all of these states are managing it, and you have to decide, how is my state dealing it? Let's turn to Tennessee because it's dealing with it in a different way, right? Tennessee is really regulating individual uses, right? So it's not looking at it on this broad scale or even on this privacy kind of governance scale. The idea is there's certain uses of AI we want to make sure that there's human review of. This tends to pop up with chatbots in the mental health space. There's a law in the books for Tennessee for that. You want to make sure that people know that they're dealing with an actual human when they're talking about mental health and therapy. That's an important thing here. And also when you're dealing with any type of medical information. So that's kind of where the law in Tennessee is going right now. But you don't see some of these other statutes that are popping up in Illinois and Colorado, Connecticut, New York coming. And then you have the California model, which doesn't really, it's not operating in terms of one comprehensive state model. Every legislative session, a new crop of laws pop up kind of focused on privacy or governance, data management, or employment law. And it's kind of up to the consumer and the employers to kind of figure out how those things all meld together. So that gives you kind of a sense of where the laws are going. You have states like Illinois and Massachusetts who have said, we're going to take our existing human rights law and we're going to create a bill focused on AI that basically says if you use AI in a discriminatory manner, it violates the law. We're not asking you to test your system. We're not talking about your governance. But if you put an AI tool out there and you apply it to an Illinois in particular consumer, and it discriminates, then you have violated the law and you have to immediately stop use of that. So this gives you some of the kind of broader state concepts that are happening, and every state is approaching it a little bit different. Kat, do you want to kind of sum up some of the emerging regulatory themes for us?
Sure. So just as you think about this, thinking about where are the different states landing, as we previewed in the beginning, what are the states worried about trying to regulate? What do they think that their, the citizens of their states are worried about? And what we're seeing is kind of these 5 themes, which is risk-based governance AI, employment AI growing as something that states are looking to regulate, as you see here. And I think this would be our, the one we're all most interested in, notice about AI being involved, AI being involved in layoffs, human review before hiring decisions. So that is an area where we are seeing increasingly legislations thinking about or enacting regulation. Chatbot transparency. I think we could maybe all agree on that. Maybe it's a little controversial, but you want to know when you're interacting with a person or if you're just interacting with a bot, trying to get your t-shirt you ordered that's the wrong size returned, knowing whether you're actually interacting with a human in that customer service space or not. Worker surveillance. Another big focus that I know the HR community would be interested in, whether that's from keystroke monitoring, whether that's from productivity scoring, how many widgets are you able to make? How many boxes are you able to pack and ship? How is AI involved in that? That's another area we're seeing state focus. And then for those of you, I know in Tennessee, we've got so much healthcare. And so healthcare AI is certainly where we're seeing a lot of sector specific trends building. And we'll be keeping our focus. I didn't say at the beginning, but I think it's helpful for you all to know that RyAnn and I both have deep Tennessee ties. I am currently resident in Nashville, have been for the last 2 years, and RyAnn and I are both Vanderbilt Law graduates from the 2000s when Nashville was a very different place. But we are
No
not
need to share the year.
yeah, we are not strangers to Tennessee. So we both have deep ties here. All right.
Yeah.
Okay. So RyAnn, that's kind of the world in which we're seeing the focus build. Let me see. And then so for business, bringing this back to you. And again, I shared a little bit of RyAnn's background, and I know Ron did at the beginning as well. But in her prior role before coming to join us at Littler, she was really kind of overseeing the function on doing advice and counsel and really building out their AI program. So you're getting this from someone who's been in your seat before, sitting in-house and sitting in on the legal side. What should you be doing? What should you be thinking about? What should you be raising to your leadership? So first, what AI systems are you using? Do you know what your systems are? Do you know what your licenses are? Are you sure that you have an enterprise license? What are you letting employees use on their machines? Are they locked out of the things that are not enterprise? Are they using Claude? Are they using, ChatGPT? Are they using Copilot? Are you ensuring that they're only using the ones that are set up to have the restrictions that you want to have built on that? RyAnn, do you
And
want to talk
it
about
really,
number two, or go ahead?
sure. For number one, I just want to, on that point, it really requires doing a listening tour, right? Because you can't send out an email that just says, tell me all AI you're using. Nobody's going to do that, right? You really have to be in touch with your stakeholders, go sit down and chat with them, and you might discover uses that were unexpected, right? It could be not just your basic employee answering a question, it could be your security team, you know, snapping photos of people coming into the building and using AI that's based on the internet without a license to kind of identify who those threats might be to the building, right? So it really does pop up in places that are unexpected, but that might apply to employees because that person walking in might be an employer, it might be a member of the public, right? And so you really do just have to go around and talk with people and ask how they're doing their job. It may not be obvious. And two, building one AI governance program that's aligned to a recognized framework. Everyone has to be marching in the same direction. You need a North Star. So your organization has to agree on what AI is, how they're going to respond to AI, and what their perspective on AI is, right? And you need to identify who the subject matter experts are that you want to kind of speak to that so that every time an AI question comes in, or a new vendor, or a new use, or an existing use that changes, there is one group of people that is consistently looking at that, keeping an audit trail of the people who are using it and how they're using it, and regular kind of conducting that audit and use analysis. There's lots of schools of thought on AI. We've talked about some of the employment HR side of it. But there's an entire side of AI that's based in privacy law and cybersecurity law, and there's something called NIST, which gives kind of governance principles for how to build a strong governance program. And some of that guidance can be helpful. What's true across both the privacy spectrum and the employment law spectrum is that a human has to be in the loop. And so part of creating that governance structure is ensuring that a human is in the loop.
We've got about 15 minutes left, so we'll just cover two more points quickly, which is you should have a governance program, inventory what you're actually doing, assess what are our uses that are higher risk. Are we using it in hiring? Are we using it in promotion? Are we using it in compensation? Are we using it in layoffs? Where are our built-in risk and how can we take some of that risk out of this? Or are we doing this with full knowledge of the risk? How can we remove biases or ensure we're adding the human back in the loop to pull that out at the end? Or can we change our directions into this AI system? So identifying and assessing those higher risk use, and then reviewing your processes more generally. Are we ensuring that we have meaningful oversight, notice, documentation? Are we aware of what we're doing? Are we going into this with eyes wide open?
And maybe consider slowing down the process, right? If you, for example, have an application that impacts 80,000 applicants, say in a talent recruiting process, perhaps don't roll that out all at once, right? Maybe there's a way in which you can test it out in several environments to see if it actually meets your business needs and has limited risk. And part of having that good governance will help you do that.
All right, RyAnn, with 15 minutes left, I'll let you talk about the ethical obligations behind the regulations. And maybe we've covered this a little bit, but just pausing here as you all sit in your seats and think about, what's my job and what do I need to be thinking about or raising to my leadership?
Yeah. And I'm actually going to come back to this one because I think it will be wrapped up nicely at the end.
Okay.
Because we kind of walk away at the end with giving you kind of 5 questions you should kind of always ask in your head that will help you assess your ethical obligations. And I think the next slide that talks about some of the litigation trends that are happening will help you get a sense of where plaintiffs' attorneys in particular are testing those ethical obligations, right? So it's very clear that plaintiffs' attorneys are willing to challenge AI in court, right? Regulators kind of tell us what to expect. That's the state law. But litigation tells us whether those expectations are actually being met. So let's look at some of the key landmark cases that you should know. All right, so we'll start with one of the first ones. And this wasn't a big monetary case. It was called EEOC v. iTutor Group. And this was a hiring software that basically hired tutors to teach English to mainly a Chinese population. And they found that the software that iTutor was using to hire tutors was screening out older applicants, including female applicants over 55 and male applicants over 65. This was one of the first kind of complaints that the EEOC brought in this kind of new AI and recruiting space. The case ultimately settled for a very nominal amount, $365,000. So that's not necessarily significant. What was significant about it was the theory the EEOC brought behind it, right? So generally, if an algorithm rejects an applicant, this case said that the EEOC is going to review the algorithm as an extension of the employer, right? It established that AI did it was no longer a defense, right? So AI is your agent, and that's what iTutor tells you, and you have to think about it like that. So one of these places that it pops up, particularly if we're talking about a recruiting system, is that a potential applicant can apply to your employment multiple times using one of these AI systems. And the systems do not show who's applying and how many times they have applied, and it doesn't really match applications for you. So it allows a plaintiff's attorney to test your system as much as they want, right? So today I apply as RyAnn, tomorrow I apply as Karen, and maybe my race, age, gender, any protected category changes, and they can use your system to prove their theory of the case. And that's kind of what this iTutor kind of told you. So in-house stakeholders really need to think about data management, how to close that gap when they're implementing AI, particularly in recruiting. And that's one of those kind of fundamentals that you have to think about when you're looking at kind of your ethical obligations and implementing these programs in recruiting. The next one is one I'm sure many of us have heard of because it's all the buzz in the HR world, is the Mobley case, right? People are waiting on this case with bated breath. The plaintiff in Workday alleged that the system disproportionately excluded applicants based on race, age, and disability. Mobley is a Black man who's over 40 and he suffered from anxiety and depression. He claimed he applied to hundreds of jobs using the Workday system that's deployed by lots of different employers, and that he was automatically rejected sometimes within minutes of applying. So this is one of those cases where you're seeing one of those classic Title VII theories where you have potentially a facially neutral selection tool, but it has a potentially significant adverse impact, right? So this case is significant because it makes clear that even tools like Workday, large scale, HR vendor AI tools, can be held liable for these actions. It's not just the employer that could be liable. The tool vendor could be liable as well, right? So now you have a joint liability theory that you weren't thinking about before. So that makes some of those master service agreements and other things even more significant if this case continues to move forward. It's been certified for multiple classes. Continues to move forward. Oh, sorry.
Yeah, and also I think importantly that you can't just, as the employer, turn and point to the tool vendor to say, this is all on them. We just use their tool.
Yeah.
That, you too are responsible for that tool and whatever inherent biases or processes are built into that tool as the employer utilizing it.
Yeah. So when you're thinking about ethical obligations, you really need to assess that vendor, right? Is this someone you want to have an ongoing relationship that you think is going to manage your data in an appropriate fashion, that you can have a relationship with and call and say, look, this is the problem. How are we going to work together to solve it? Because that is now, it's you aren't separate anymore. This case is saying you guys are together on this. So a third case, how are we doing on time? A third case that kind of came up is Harper v. Sirius Radio. This is an employment case that came out of SDNY, so the Southern District of New York. And this is actually a criminal case. It's not an employment case. But I think, oh, actually, I skipped over. That's Hefner. I apologize. I didn't include Hefner on this one. Harper, sorry. Ignore me. That is an important case to know, though. That is a case that talks about all of the kind of, when you go into ChatGPT, Copilot, anything, and you ask a question, there's a record being created of all the questions that you're asking. And Hefner, although a criminal case, basically says those chats are no longer private. And if you're engaging with your attorney and creating something for your attorney, or your attorney is creating something for you, and now the record could be discoverable, right? And it is no longer kind of protected by that attorney-client privilege. So that's just a separate and aside important data management tool. Harper v. Sirius is a case out of Michigan, and it really talked about adjacencies for inputs when you're talking about some of these AI management tools, right? So we know our general proxies that might go into a recruiting tool, where do you live, what's your educational background, etc. Many of us can identify those that might lead to more bias than others. But there are adjacent skills that are often assessed in these tools that have our proxies for some of the protected categories, like zip code and other things. And this case is testing theories of that, right? So it's not enough to just be looking out when you're looking at these inputs for the classic protected categories. You also have to think of things in terms of proxies. And then the last case to think about is this case, Kistler v. Eightfold, right? This was a case that was brought by former EEOC commissioners. It's looking at one particular HR tool that creates something called a match score, meaning applicants kind of load their resume data, they load up all the skills that they use, and it generates, based on your skills and background, a score to see how much you fit the job requisition number. And that score can kind of follow you through the life cycle of your employment, depending on how far the employer has kind of adopted the integration or software. So with this Eightfold case, they're saying that that record that it creates, that match score, is the equivalent of a credit score. And it's a credit score that you should be able to correct and get notice of, right? And we want to regulate it basically just like we would regulate a background screen or a criminal screen under FCRA. And so that's kind of another important kind of theory to watch and know, because these are all things that are indicating what your obligation is now and what it might be in the future. So we've talked a little bit through the case law about what some of the plaintiffs' theories are coming up with, right? One, we have vendors and agents, the joint employer theory. We just talked about that, right? Like you can't think about these things in a vacuum. AI made me do it is not an excuse. And you and the vendor may be jointly liable for any decisions that are being made in the employment space. We've talked about disparate impact without intent. That's that idea of, it's the adjacencies. It's the idea that my tool is neutral, but it's discriminating anyway, right? And I have an obligation to know that and to test that and find that out before I go and put it out in the world. We talked about the consumer report and testing for that. And the last theory that we didn't quite get into is this idea of the impact in the wage and hour space, right? So as more and more efficiency tools are used, managers in particular are able to relax a bit. But we're talking about 360 reviews and potentially drafting reviews and comparing reviews. To the extent that those actions and those efficiency tools take away roles that managers traditionally played, the question becomes, what is the definition of manager? Do they still have kind of exempt status under wage and hour laws? And when you're dealing in a collective bargaining context, can they still meet the 211 standard under the National Labor Relations Act, such that they are excluded from the bargaining unit and not eligible to vote in the face of an R case petition, right? So that's kind of another exposure area that you have to think about in terms of it's changing how people do work and what the classic definitions of employee and employer were previously under traditional kind of statutes.
Yeah, and I think that's one that's worth emphasizing just as we continue to have more and more of these managerial functions where the manager is delegating some more of it to the tool. And as RyAnn said, there are these tests under the FLSA and state laws for whether someone qualifies for exemption status that really are fact dependent upon what that leader is doing. It's not just their title, their job description, it's their actual functions. And if more of that gets delegated to these AI tools, have you lost that exemption status? And then, RyAnn and I both have our background as labor lawyers dealing with unions. And we see this on the horizon as well. That test under the National Labor Relations Act is very stringent for the actual exercise of those authorities under what's called Section 211, which is what defines supervisors. So is it on the horizon that some of the folks that we say are supervisors and excluded from being in a bargaining unit, from being organized by a union, could become eligible for organizing because of their use of AI tools to perform some of those job functions that had put them in the category of supervisor? So just a really important one. I don't know if it's a today, but as this continues to evolve, something to keep on your radar that you might have to reassess if you've already put people in the buckets of exempt, non-exempt, employee, supervisor under the NLRA as these tools evolve. So we got 3 more minutes. We knew we'd have plenty to talk about in this hour together. So let's, RyAnn, give us the takeaways. What should these HR professionals really be thinking of and walking away with today?
I'm going to try to do it in 1 minute, so we have at least 2 minutes for questions. There are really 5 questions that you should be thinking anytime you encounter an AI tool. Is the AI making a decision, right? Is it influencing an employment decision? What data is the AI using? Has anyone tested this tool at all for bias? And I don't just mean that lovely Excel spreadsheet the vendor hands you and says, we tested it, it's fine. Someone needs to test it on your data. Can we explain the outcome of this tool? Meaning, if we rely on whatever this output it gives, can we explain it, whether it be in the court of law, before a regulator, or even to our own employment, our staff, what it's doing and why it did what it did? And then if AI gets it wrong, has someone been designated to be accountable for it getting wrong, right? And that goes back to that kind of governance problem. Who is accountable if AI gets it wrong? So you should think about that before entering into any kind of AI-based relationship. We also included a handy chart here that talks about things you could think about before you implement AI, while you're using AI, and after. Know that it's an ongoing process. People like Kat and I and other Littler attorneys are here to help and assist, to kind of support some of those questions. But this is a helpful chart that you can use to think about as you start to look at governance or apply existing governance.
Yeah, and so to give you just kind of a final takeaway, I think, AI is kind of it's a modern, it's an innovative word. But if you go back to everything that you know about HR and employment law and what's required generally under the laws, removing bias, ensuring there's no discrimination built in, treating everyone the same regardless of their membership in a protected class, providing notice when required, ensuring compliance with privacy. Those fundamentals are all the same. I use an analogy again because my day job is as a labor lawyer. The laws that used to apply about what employees can talk about at the water coolers don't change when the water cooler becomes social media. The same principle is true here. Just because it's now AI doesn't change the rules. So just taking a pause, asking yourself those questions that you're used to asking yourself, knowing and having knowledge about how the tools are being used, really important, and kind of the way to ground yourself when you're dealing with these ever-evolving tools that are going to continue to change, on not just a yearly basis, but a day-to-day basis as to what the tools are and what they can do for us in our jobs. I haven't seen any questions, which must mean we answered everyone's questions proactively before they even had to send them, RyAnn. But we are available. You've got our information. We're both at Littler. And we were really thrilled to get the opportunity to present to you all today. Hopefully this helped you in your framing of AI and took a little of fear about it and made you feel empowered in your role as to what you should be assessing and the questions you should be asking. So we are very privileged to have gotten to speak to you and hope you have a great day.
Yes, and again, this was a lot of good information. We really appreciate the presentation today. and we'll definitely be able to use this information in the future. So again, thank you for your time.
Wonderful to see
Goodbye,
you.
all. Have a great one.